Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola law firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Also assisting me today is Brandon Kaufman. He's a student here at Nassau Community College and involved with the radio station WHPC. My guest today is Andrew Thayler. He's a prominent attorney here in Nassau County. He also acts as a trustee for the Bankruptcy Court and is a past chair of the Bankruptcy Committee, and he's a past dean of the Nassau Academy of Law and very involved in the Bar Association and the business community. And he's going to talk about whether bankruptcy is for you, whether personal bankruptcy. Andy, welcome back to Law You Should Know. And Brandon, thanks for participating in the show. And please start with your first question.
Okay, so what is the definition of bankruptcy?
Bankruptcy is, for individuals, an opportunity for them to get a fresh start from the debts that they owe. Essentially, people run into difficulties either because perhaps they had a medical situation or went through a divorce or had a business reversal, and this allows them to, in certain circumstances, get rid of their debts. We call it a discharge in return for making available to their creditors assets which we call are not exempt, meaning that they're not allowed to keep some of those assets.
And they cannot be discharged?
Well, there are certain debts that can be discharged. Basically, for public policy reasons, there are certain debts that the law allows to be discharged, others that can't. And the law allows people to keep certain properties so they don't become a public charge and go on welfare. So the law is designed to allow people to have a certain amount of assets so that they can go on with their lives, but not maybe keep everything.
Okay.
What determines whether or not you can keep an asset or lose it?
Okay, that's a good question. Here in New York, there are exemption statutes. There are also statutes under federal law. Federal bankruptcy law trumps state law in general, but the federal law says that people can opt out for either federal exemptions that are set forth in the federal statute or choose the New York State exemption statute. So you choose one scheme or the other. You can't combine them. And depending on what type of assets you have, we would determine in talking to the client where they would most benefit. So there are these lists in both statutes. For instance, here on Long Island, if you own a house, you can exempt up to $165,500 of equity in a house over and above any mortgages that you might have on the property or any tax liens that might be on the property. Under New York law, that exemption is under the federal law. The exemption is a lot less, more about $23,000 or $24,000. So you can see if someone owns a house, they would opt to take the state exemption as opposed to the federal exemption.
And that's a house that's not underwater?
Well, that's right. If the house is underwater, then there is really no equity in order to protect.
So bankruptcy may not help you with that?
No, but what it would do is it would discharge the underlying note, so that if you went through a bankruptcy, even on a house that had no equity in it, you would be able to discharge your personal obligation on the note, even though the bank would still be able to proceed to foreclose on the property itself in order to get paid just from the proceeds of the property. But for instance, if you got a discharge, they wouldn't be able to garnish your wages or seize bank accounts later on.
But if you had some income, you might be able to do a short sale or find some way to keep the property and take advantage of bankruptcy as well?
Well, a short sale is where you're actually selling the property for less than what is owed to a stranger in an arm's length transaction, and in that situation you would no longer be in your house.
But if you would the threat of bankruptcy or filing bankruptcy help you take advantage of a lower rate or help you, have the mortgage reduced?
It's not necessarily the threat of the bankruptcy, although there are procedures where you can seek to do a modification.
A modification.
Right. Okay. You can do that either inside or outside of a bankruptcy. To the extent that you want to do a modification in a bankruptcy case and have the bankruptcy court sort of monitor the modification, there's something called a loss mitigation program. There's a program in the Eastern District of New York, but not all of the judges have opted to participate in it. So if you do file a bankruptcy, you don't know who your judge is going to be in advance, and so you may not be able to participate in that program. But what they do is they can't. The bankruptcy court can't force the bank to modify the mortgage, but what they can do is force them to follow their own procedures and to follow up on the documents that the people have asked for and to review everything and not just ignore them or ask for the same documents over and over again, which is an issue that comes up.
Anyway, it sounds very complicated, but we're going to turn you back over to Brandon. Yes.
All right. And there are two types of statutes for bankruptcy?
For personal bankruptcy.
Personal bankruptcy.
Well, actually, there's one statute. It's called the Bankruptcy Code, and in that, for individuals, there's what's called a Chapter 7 within that code, and a Chapter 13. Generally, those are the two major chapters that someone might choose to pursue in filing a bankruptcy.
What's the difference between the two of them?
Chapter 7 is what we call a straight liquidation. So essentially, the deal there is that the person who files bankruptcy is going to relinquish to a bankruptcy trustee all of their assets to this trustee, whose job it is to try and liquidate property and make distribution to creditors. And in return for that, the individuals filing bankruptcy can discharge most or maybe all of their debts. Now, with regard to assets, there are certain assets that people get to keep. So, for instance, generally household goods and furnishings and wearing apparel are going to be exempt. There are certain dollar amounts, but that's not something that a trustee is interested in pursuing.
So basically, you have no assets, that you don't have much assets, and you can protect a little bit.
Right. I would say probably 98 to 99% of the bankruptcy cases that are filed throughout the country are filed by people who either don't have any non-exempt assets, or the non-exempt assets that they have just aren't worthwhile pursuing to try and sell to make a distribution to creditors, and they wind up discharging all of their debts. Now, as far as the debts are concerned, you asked about that. Most debts are discharged, but for public policy reasons, some debts may not be discharged. And most people would be able to figure this out if they weren't told by an attorney. But the law doesn't want to reward, for instance, bad behavior, and it doesn't want certain people who rely on getting paid to not get paid. So, for instance, if you owe a domestic support obligation for child support, that's not something that's going to be discharged in the bankruptcy. Or if you took a shovel and you hit me over the head, you committed a crime or an intentional tort, the law is not going to let you walk away from that type of obligation. Or if you committed a fraud in procuring money from a creditor, that's something, if it's established, will be a bar to discharging those particular claims.
Restitution might not be discharged.
Restitution would not be discharged. Parking tickets and fines. The government always wants to be able to collect money, so if you haven't paid income taxes or sales or withholding taxes, fiduciary taxes are definitely never discharged. Income taxes, maybe if there are certain vintage and other elements are met.
And student loans are not dischargeable.
Generally, student loans are not dischargeable. In New York, in the Second Circuit, you have to establish undue hardship in having to continue to make those payments. And that basically has been equated to you're just not having the ability to work and make any kind of meaningful amount of money like for the rest of your life. And so it's a very, very difficult burden to establish a discharge of a student loan. You may be able to work out some sort of forbearance or payment arrangements, but they will fight tooth and nail to avoid you being discharged and being able to discharge those.
Because the assumption is eventually you'll have some money to pay it back.
Correct. If you're able-bodied and have the ability to work at some point in time, yes.
All right. Excuse me. When should you consult with a professional about personal bankruptcy?
Okay. We find a lot of times that people are getting into financial difficulty, and they're not realizing that if they filed a bankruptcy petition, they might be able to save assets because they're exempt, instead of losing those assets to creditors when they're trying to correct things when that's not going to be possible. So, for instance, if someone's only paying the minimum amount on their credit cards, there's large interests that are associated with those cards. If they sat down and they figured out how long it would take them to pay those debts just by paying the minimum, they would find it might take them 20 or 30 years, and they would pay multiples of the amount of debt. Other situations are where people are borrowing from one card to pay another card. They really just don't have enough money to pay, the money that they're spending each month, so they really haven't budgeted things. We find that people will tap into pensions and retirement accounts that otherwise would be exempt in order to pay certain creditor claims. So that's really not a smart thing to do. Or people might take home equity loans against their house in order to pay their credit card debts, and they're jeopardizing a loss of their home by having given a lien on their house as opposed to a credit card, which might otherwise be discharged. So those are just some of the situations where people should think about talking to a professional. Obviously, if they've been sued or they're getting dunning letters, or they're concerned about losing their home, those are situations where they would want to consider bankruptcy.
You said losing a home after dunning letters. Are dunning letters different, or are they related to home in some way?
No, it's not related to a home in any particular way. A dunning letter is basically just a demand for payment. So, for instance, if you had a credit card and you didn't pay the card at the end of the month when it was due, at some point the credit card company is going to send a letter saying, oh, by the way, you missed your payment. First letter is going to be kind of friendly. You may not have realized it, and, make your payment. And then as the months go by, the letters get stronger. And if you don't make payment, then it goes to other enforcement procedures. It might go to an attorney. The attorney might send a demand letter. Then it could lead to a lawsuit. They could sue you. They could wind up getting a judgment and things like that. As far as a mortgage is concerned, they would basically send the same type of a letter. They would say, your mortgage payment hasn't been made. They might have programs where they would give you maybe a forbearance. They may or may not offer you something like that, but at some point they would start a legal proceeding called a foreclosure, and if everything went, to the end, they ultimately would get a judgment of foreclosure, and they would sell the house.
And if you did not have a house, people getting dunning letters, maybe they're in quicksand as far as their credit card bills. They have a lot of bills. They keep getting bigger and bigger and bigger. And you're saying there's a solution. That solution might be bankruptcy, to wipe their debt clean, to get a fresh start.
That's right. I'm not saying people would go into bankruptcy, without thinking it through. For one thing, you only can file a Chapter 7 bankruptcy and receive a discharge of your debts once every 8 years. If your debt was not very substantial, we would be looking at other alternatives to see how you might be able to deal with the debt. You might be able to negotiate with the creditors and get them to agree to take a certain amount of money less than what they're owed.
And you would help them out with that as well?
We could assist them with that as well, yes.
Okay. And there's going to be some negative consequences of bankruptcy. We'll discuss a little bit later. We have to take a short break now. When we return, let's continue our discussion with attorney Andrew Thayler about if bankruptcy is for you. You're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College, and also over the internet at ncc.edu/WHPC. We'll be back in a moment.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, helping both the public and lawyers since 1899. They are the largest suburban bar association in the country. The Nassau County Bar Association offers clinics where you can meet privately with an attorney to prevent or solve legal problems involving Hurricane Sandy, foreclosure, wills, or elder law. Speakers on almost any legal topic are also available to schools or community groups. They can also help lawyers advance their legal careers and offer a place to network. Learn more about the Nassau County Bar Association by calling 516-747-4070 or visit nassaubar.org.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. Our guest is attorney Andrew Thayler. He's a very experienced legal practitioner in the area of bankruptcy, and has been a trustee for the Bankruptcy Court. We'll find out what that is soon. He's also he's a past dean of the Nassau Academy of Law, and he's explaining what personal bankruptcy is about.